And welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today will be the day I earn that subscription. For today's story, we are doing our continuing roundup of Supreme Court speedrunning. Yes, it is yours truly, Uncivil Law, here in Los Angeles, in order to go to VidCon. But that will in no way preclude us from doing Supreme Court roundup. I have got my iPad in front of us, so I can't put the decisions on screen and show the text to you, but I can read them to you, which is just as good. So no problem. So yeah, we are here today. iPad in front of us, so I can't put the decisions on screen. Why am I hearing myself show that text to you? But I can read them to you, which is just as good. So no problem. So yeah, we are here today. iPad in front of us, so I can't put the decisions on screen. Why am I hearing myself show that text to you? But I can read them to you, which is just as good. So no problem. So yeah, we are here today. iPad in front of us. Hold on. Hold on. Why did it start playing back the audio? That doesn't make any sense. Good morning. I'm trying out this new microphone, by the way, to try to improve the audio quality. The microphone is this Shure MV88, plugs right into the lightning jack. But I don't know why you were able to hear me back, why it started giving me audio back. I don't understand this. It should be the same microphone. It's cutting out, but occasionally through it, you actually sound pretty good. Excellent. Yeah. Sound audio's good. Yeah. Sounds great as of now. Okay, great. Yeah. So we're using this external microphone thing, and we'll see how it goes. Sounds a lot better than the brewery. Well, how do you think I learned these lessons, right? We learn these lessons the hard way. We learn these lessons by having problems like the brewery, and then we're like, the audio sucks. What if we tried this external mic solution? So we'll see if that works. I'm also glad at this point that I started 5 minutes early because we can see what's going on. What is VidCon? It's a convention relating to YouTube, kind of video. It stands for Video Convention, VidCon. So it's a convention of people who are doing online stuff, TikTok, YouTube, whatever. And we are trying to learn, or at least I'm trying to learn how to be a YouTuber. Incidentally, I don't know how many of you noticed, but as of this morning, this channel is verified. I've got a check mark now. So that's exciting. Yeah. And I'm just waiting for the opinions to be released as well. So, yeah, that's exciting. I'm verified now, so I'm like official and stuff. My flight was fine. The wedding isn't until this afternoon. So I'm obviously going to go to the wedding, guys. I'm not that dumb. Oh, I got to meet a lot of those guys yesterday because we had a little party last night. So I got to meet Runkle the Bailey last night. I got to meet Joe Neerman last night. I got to, of course, Alita was there. And Legal Mindset from Korea, Andrew, was there. So that was very cool of him to be there. And we had a great time meeting each other and stuff like that. Alita is married. She's military married. So the first time around, as it were, it was just the paperwork. So this is the ceremony. The ceremony is 6 years. The ceremony is 6 years into the marriage. I mean, what do you know? It's just, yeah, it's it's that kind of thing. They got married 6 years ago, and now they're having the ceremony for it. Yeah, that's how they're rolling. So yeah, that's what's happening. And I didn't even know VidCon was happening at the same time as the wedding. But once I found that out, I'm like, oh, that's really great, because now I can write off this entire trip as a business expense, because now it's business development. So that's pretty badass. How's the bridesmaid dress fit? I don't know. Yeah, I'm not sure what the deal with the loop is. I'm not sure why there was a loop at all. I don't understand that. Do I think NFA tax stamps are challenged in light of Bruin? No. No. You need a lot more steps. You need a lot more steps before you're even thinking about NFA tax stamps. You think Dobbs is going to be out today? We'll find out. There's 9 opinions left to drop. We're going to see which ones come out today. You think it's going to be Dobbs? I mean, every day someone says it's going to be Dobbs. Richard Hogue is not here. Law and Lumber's on his way. Law and Lumber's on a flight as we speak. So he's on a flight as we speak. We want it to be Dobbs. They're reliably informed as Dobbs. Well, I mean, there's not a lot of options left. It's either today or it's whatever it's going to be next week, right? I mean, presumably. So it's either today or it's... when? Do they have opinions announced on the calendar yet for next week? I don't even know if they have calendars announced on the calendars next week. So it's either today or it's going to be, next week. There's not a lot of options. Yeah, there's nothing on the calendar yet. That makes sense. So I don't think it'll be Monday. It's more likely it'll be whatever the last day of June is, which is that Friday probably. Wear sunscreen? I am wearing sunscreen on my face. I'm wearing that Tiger Grass color correcting sunscreen. Dr. Jart's, which gets the green to help counteract the red, and sunscreen. I got all the things today, man. 2 minutes to go, man. Looks beautiful where you are. It is nice out here. It's a nice day. Love the shirt. This was a one-off. I had this made just for VidCon, so that I'd have something I could wear, so, represent the brand. I figured between that and the hat, I'd be pretty easy to recognize. Lawn Lumber is coming. He's on a flight as we speak. Yeah. Anaheim Convention Center, that's right. I want to get this shirt. Well, this shirt is a one-off. But, we might have other shirts made up. Love the flowers behind you. It's a nice day today. It's a nice day in LA. If it weren't for the lousy administration, I understand the charm. Although, incidentally, I did create merch on Streamlabs. So, yeah, the bot from time to time is probably going to give you the link from Streamlabs, and if you want to donate that way instead of giving to Super Chats. And I believe if you click that link on Streamlabs, that it gives you a polo option that I designed. So if you want to buy something, you can buy it through Streamlabs. At least the polo. Nate is currently still sleeping, and Mike is coming. Yes, I have it on my I have it on my laptop or my iPad, so I'm gonna have to read it to you. 850, 900 people watching. That's really nice. Thank you. Auction off the shirt? I could do that. That'd be funny. We need to pick a law tip of this wedding. We'll see what we can do. Well, mine is not updating. Oh, who cares? There it is. We have the first case is Becerra. I'm not sure how you found out about it before I did, but okay. Kagan, 5-4. Let's take a quick look at this thing. Alright. Once a person turns 65 or has received federal disability benefits for 24 months, he becomes entitled to benefits under Part A of Medicare. Part A treats coverage for, among other things, inpatient hospital treatment. Medicare pays hospitals a fixed rate for such treatment based on the patient's diagnosis, regardless of the hospital's actual cost, and subject to certain adjustments. One such adjustment is the disproportionate share hospital adjustment, which provides higher than usual rates to hospitals that serve higher than usual percentage of low-income patients. To calculate the adjustment, the Department of Health and Human Services adds together two statutorily described fractions. The Medicare fraction, they're going to make me do math, aren't they? The Medicare fraction, which represents the portion of hospitals' Medicare patients who have low incomes, and the Medicaid fraction, which represents the portion of hospitals' total payments who are not entitled to Medicare and have low incomes. Together, those fractions produce a disproportionate patient percentage, which determines whether a hospital will receive a DHS adjustment and how large it will be. Not all patients who qualify for Part A have their hospital treatment paid for by the program. Non-payment may occur, for example, if a patient exceeds Medicare's 90-day cap per spell of illness, or if a patient is covered by private insurance. Such limits on Medicare's coverage prompt the question raised here. Whether patients whose Medicare insures but do not pay on a given day are patients for whom such days were entitled to Medicare payments for the purpose of computing a hospital's disproportionate patients percentage. I'd like to say I understand the issue, but I really don't. A 2004 HHS regulation says yes. If patients meet the basic statutory criteria for Medicare, that is, they're 65 or disabled, then a patient counts in the denominator, and if poor, in the numerator for Medicare. Respondent Empire Health Foundation challenged the regulations inconsistent with the statute. The Ninth Circuit agreed. The court focuses on the state's statute's use of two different phrases. Entitled to Medicare benefits.
This shit works. It works so good.
It works good. Yeah, I know. So you can join me speed reading. You want to sit down? Sit down.
I'm about to get something to eat. Oh my god.
No, it's fine.
The people. What's going on?
No, yeah, it's fine. Qualifies the Grand Certiorari to resolve the conflict. In calculating the Medicare fraction, individuals entitled to Medicare are always qualifying under the program, regardless of whether they receive payments for part or a hospital stay. I don't really understand this issue. It's dealing with some really esoteric bullshit about Medicare reimbursement rates and who does or does not qualify as a patient under some obscure provision of something that I don't completely understand the issue.
And this shit went 5-4.
And it's 5-4.
This is the most controversial one we got. Everything else is like 6'3". Oh,
Nate's got the branded shirt. Nate's going to VidCon.
Oh yeah, boom.
And just in case you forget who he is, this is our first time actually meeting in person too.
That's true. I feel like we've known each other for years though. But the thing is, we've been hanging out for like what, 2 years together?
Something like that. No, yeah.
Oh, we got to get a wide king low. Everybody's clapping. Yay! So let me go get something to eat. Listen, people, we're going to be streaming from VidCon too, so.
I want to eat.
Mom said you're still doing this.
Well, I want to eat too.
I'm not sitting right now. I'm going to go do my thing and get ready to eat.
All right.
But you get the car keys, right?
No, they're still up there, I think.
All right, cool.
Should be. Should be on the table up there somewhere.
Cool. I'm waiting for you. I'll be back, though.
Peace out. That was Nate the lawyer. We are crashing at a hotel together near the convention center. Nate's totally messing with the contrast on the camera. Yeah. There's that. So, yeah. I could see him coming away too. I think he was trying to stay on my line of sight, but I saw him in my line of sight. I just couldn't see who it was, and I saw him coming over this way. I'm like, who is this asshole who's coming to interrupt my stream, all right? It was Nate the lawyer. It's a very technical case. Let's see. Okay, so we can read what Scottish Block says about it. All right, this is according to the Scottish Blog. This is a technical case, but the stakes were high for hospitals that receive Medicare. The court upholds HHS understanding of Medicare fraction. This is probably just Chevron. I mean, probably, right? I mean, if it's a reasonable interpretation of a stat, it's probably just Chevron. This case is about how Department of Health and Human Services calculates special Medicare payments to hospitals that serve a high percentage of low-income patients. In particular, it challenges the case to HHS's interpretation of the phrases entitled to and eligible for to mean all patients who qualify for Medicare or Medicaid. Thomas, Breyer, Sotomayor, and Barrett joined Kagan. That's a strange mix. HHS interprets the statutory description Medicare fraction to mean someone is entitled to benefits if he qualifies for Medicare, even when Medicare is not paying for part or all of his stay. That kind of mentions, it makes sense. Kavanaugh dissents, which is rare. Alright, so something, Medicare repayments. Scottish blog says it might matter to the tune of billions of dollars. So, we'll see. Kagan, let's see, because Alito's after Kagan. So it's Alito, Breyer, Thomas, Gorsuch. Is Sotomayor more senior than Kagan? I can't remember right now. Sotomayor might be more senior than Kagan. I don't know. I have to double check. Yeah, Sotomayor is more senior than Kagan? Okay. Yeah, alright. Yeah. So Sotomayor. So Sotomayor is more senior. Okay, yeah. How goes the swallowing? We're trying to get more swole. Oh, you guys will like this, by the way. As some of you guys have already known, my last official day at my current job is July 2nd, and I've already turned in my timesheet. So, I'm done. Kavanaugh explains because the interpretation is not the best reading. Chevron is radioactive. So there seems to be some appetite for overturning Chevron. Yeah, so I'm pretty excited about that. Freedom, exactly. I'm already happier. And the channel's verified now. And soon I'll be getting a play button, which is going on my counter behind me. And I think I'm going to put my Supreme Court admission certificate on the counter behind me as well, because I'm admitted as a lawyer at the U.S. Supreme Court, so I get a cool little certificate. And I figure I put that on the counter behind me next to my play button, and that'd be good. So, you can look forward to that at some point in the future. What is Chevron? Chevron versus National Resource Defense Coalition. Chevron versus NRDC. It's a major underpinning case of administrative law. Basically says that administrative agencies' interpretations of statutes are correct unless absurd. And the federal judiciary kind of bends over backwards to the federal judiciary. Apparently, we have Dobbs. Okay. So we have Dobbs now. So we're going to learn about abortion law. I'm going to understand, describe, analyze, and explain abortion law in under 10 minutes. No problem. This is the one. This is the one you guys paid for, right? It is by Justice Alito, with Roberts concurring. And I will read it to you as soon as I have it. Don't spoil it for me. I get to read. Someone said Roe and Casey's overturned. Don't spoil it. Spoilers. How do you know that? I thought Scottish blog was about the fastest one. Maybe you're just assuming it. Maybe you're just assuming it's overturned because that was what was true in the draft opinion. Oh, Roe and Casey are overturned. Scottish blog agrees with you. I still don't have an opinion. Alright, here we go. Here's the PDF drop. Alright, so some of this may sound familiar because we've read the draft opinion. We'll see how much of it remains true. So we'll come back to this probably before the end of the day. Guess what I'll be talking about most of the day at VidCon probably. Alright, here we go. Dobbs versus Jackson. Mississippi's Gestational Age Act provides that except in a medical emergency or in the case of a severe fetal anomaly, a person shall not intentionally or knowingly perform or induce an abortion of an unborn human being if the probable gestational age of the unborn human being has been determined to be greater than 15 weeks. Respondent, Jackson Women's Health Organization, an abortion clinic, and one of its doctors challenged the act in federal district court, alleging it violated this court's precedents establishing a constitutional right to abortion, in particular Roe v. Wade and Planned Parenthood v. Casey. The district court granted summary judgment in favor of respondents and permanently enjoined enforcement of the act, reasoning that Mississippi's 15-week restriction on abortion violates this court's case forbidding states to ban abortion pre-viability. The Fifth Circuit affirmed. Before this court, petitioners defend the act on the grounds that Roe and Casey were wrongly decided, and the act is constitutional because it satisfies rational basis review. Held, the Constitution does not confer a right to an abortion. Roe and Casey are overruled, and the authority to regulate abortion is returned to the people and their elected representatives. Well, two things of note. First of all, definitely not hiding the ball. Second of all, this language is different than in the draft. Not that we didn't expect that, because of course we did. There's going to be revisions. But like the ultimate thing is the same. It's right in the first line. The Constitution does not confer a right to an abortion. Roe and Casey are overruled, and the authority to regulate abortion is returned to the people and their elected representatives. Well, that's the thing that just happened. Twitter may in fact crash. The critical question is whether the Constitution properly understood. At least they won't be talking about the gun thing that much anymore. So they won't be talking about concealed carry in all the places, because they'll be too talking about how they can't do the abortions. The critical question is whether the Constitution properly understood confers the right to an abortion. Casey's controlling opinion skipped over that question and reaffirmed Roe solely based on stare decisis, which is kind of true. A proper application of stare decisis, however, requires an assessment of the strength of the grounds on which Roe was based. Roe's pretty garbage, on its own technical merits. I don't take any position on the ultimate morality of abortion. I'm a legal analysis. Someone else can do the moral decisions. The court therefore turns to the question the Casey plurality did not consider. First, the court reviews the standard that the court cases have used to determine whether the 14th Amendment refers to the liberty to protect this particular right. The Constitution makes no express reference to a right to obtain abortion, but several constitutional provisions have been offered as potential homes for the implicit right. Roe held that abortion right is part of the right of privacy that springs from the 1st, 4th, 5th, 9th, and 14th Amendments. Dobbs, baby.
I know, I just found it just so.
Dobbs, sit down. Sit down, Dobbs.
This shit is fucking crazy,
sit down,
bro.
Dobbs. It's over.
It's official.
It's over. It's all official. Yeah. Others have suggested that support can be found in the 14th Amendment Equal Protection Clause, but a theory squarely foreclosed by the court's precedents, which established the state's regulation of abortion is not a sex-based classification, and is thus not subject to heightened scrutiny that applies to the classification. Okay, rather the regulations of abortions are governed by the same standard of review as other health measures, so it's not a sex-based regulation. Abortion is not a sex-based regulation, so therefore intermediate scrutiny does not apply. Therefore, we're back to rational basis, which means the states can pretty much do anything they want. Next, the courts examine whether the right to obtain abortion is rooted in the nation's history and tradition. This is a bit ironic coming out of Thomas's yesterday, right?
Yeah.
With history and tradition, right?
Here we go.
Okay. The court finds the right to abortion is not deeply rooted in the nation's history and tradition.
The Pavlov, was it not Pavlov, what's the test? Palco test.
Palco test, you got it.
Palco
That's
test.
right. Nice callback with Palco.
Yeah.
I'm just saying though. That's a nice callback.
The big brain right here,
That's
baby.
nice. I respect. The court finds the right to abortion is not deeply rooted in tradition. The underlying theory in which Casey rested, the 14th Amendment due process substantive provisions, as well as procedural for liberty, has long been controversial. Well, that much is damn true.
Yeah, that's true.
The court's decisions have held that the due process clause protects two categories of substantive rights: those rights guaranteed by the first 8 amendments, and those rights deemed fundamental not mentioned anywhere in the Constitution. In determining whether the right falls in these categories, the question is whether the right is deeply rooted in our history and tradition. Please make note here, by the way, it's our history and our tradition, and whether it's essential to our concept of order and liberty, because you see this language also in Heller, incidentally, because they say, well, the Second Amendment is essential to our concept of order and liberty, whatever might be said for other people's concepts of order and liberty, but I digress. Citing Timms. Interesting. The term liberty alone provides little guidance. You think? Thus, historical inquiries are essential as to whether the court is asked to recognize a new component of liberty. Interpreting what is meant by liberty, the court must guard against the natural human tendency to confuse what the 14th Amendment protects with the court's own ardent views about the liberties they should enjoy. Holy shit, dude.
Throwing shade at the road.
Throwing shade. Shade. Row shade.
And essentially, they're saying that the court is not supposed to make policy. The court's supposed to interpret the Constitution.
Yeah.
And Roe was a policy decision that really is not rooted in any type of anything.
For this reason, the court has been reluctant to recognize rights that are not mentioned in the Constitution. That's true. Guided by the nation's history and tradition that map the essential components of the nation's concept of order and liberty, the court finds the 14th Amendment clearly does not protect the right to an abortion. Up until the later part of the 20th century, there was no support in American law for a constitutional right to obtain an abortion. No state constitutional provision had recognized that right. Until a few years before Roe, no federal or state court had recognized the right. Yeah, at the time of Roe, as memory serves, I think 4 states allowed for abortion.
I think so. No, well, I think it was 50. I think it was a higher split. I think it was there were 26 states that banned it, but I think some states didn't speak to it. So.
Okay. Anyways, nor has any scholar treatise. Indeed, abortion has long been a crime in every single state. At common law, abortion was criminal in at least some stages of pregnancy, and was regarded as unlawful and could have very serious consequences at all stages.
That's true.
American law followed the common law until a wave of statutory restrictions in the 1800s expanded criminal liability for abortions. By the time the 14th Amendment was adopted, 3/4 of the states had made abortion a crime at any stage of pregnancy.
Okay.
The consensus endured until the day Roe was decided. Roe either ignored or misstated this history in case it declined to reconsider Roe's faulty historical analysis, throwing some serious Roe-related shade right now.
Yeah. This is definitely shade at Roe.
Respondents' argument that history does not matter, yeah, we know how that's going to work, given what we read yesterday,
Yeah,
flies in the face of the standard the court has applied to determine whether a asserted right that's nowhere in the Constitution is nevertheless protected. The Solicitor General repeats Roe's claim. It's doubtful abortion was ever firmly established as a common law crime, even with respect to destruction of a quick fetus, which, by the way, at this point means one that's moving in the womb.
Oh shit! I just remembered.
Are you right?
I got everything right. This is the last one. I'm 100% for my predictions for the Supreme Court cases.
Okay.
I'm sorry. I didn't mean to. I just thought about it. I was like, oh shit, the Oracle is back, baby. Go ahead, continue to read. I'm sorry. It was just a realization, like, oh shit, I was perfect this time. Go ahead.
Okay.
It's like very hard to do. That's very hard to do. Very hard to predict these cases. Go ahead. This one was easy.
Anyway, turning back to the analysis. But the great common law authorities, Bracton, Koch, Hale, and Blackstone all wrote that post-quickening abortion was a crime. Moreover, many authorities assert that even pre-quickening abortion was unlawful, and as a result, an abortionist was guilty of murder if the woman died in the attempt. The Surgeon General suggests that history supports an abortion right because the common law struggled to criminalize abortion before quickening, but insistence on quickening was not universal. And regardless of the fact that many states in the late 18th and 19th centuries did not criminalize pre-quickening abortion does not mean anyone thought the states lacked the authority to do so. Instead of seriously pressing the argument the abortion right itself has deep roots, Supporters of Roe and Casey contend the abortion right is not integral part of a broader entrenched right. Roe termed this right privacy, and Casey describes this as freedom to make intimate and personal choices that are essential to a person's dignity and autonomy. Ordered liberty sets limit and defines boundaries between competing interests. Roe and Casey each struck a particular balance between the interests of a woman who wanted an abortion and the interest of what they termed potential life. But the people of the various states may evaluate those interests differently. The nation's historical analysis of ordered liberty does not prevent the people's elected representatives from deciding how abortion should be regulated. I can already see the Chuck Schumer speeches in my head a little bit, because with yesterday with the gun case and taking out of the Democratic control, the gun issue, right? And this becomes Democrat control and talking on both sides of their mouth. I can already see the talking points in my head.
They are talking out of both sides of their mouth. And one, you got to actually look to the past history. And this one, let's just they're talking big time.
For the 2,000 of you who are currently watching, thank you very, very much for joining us with this live stream outside of Los Angeles, who I'm sure the entire city will be thrilled with this momentous decision. Finally, the court considers whether the right to obtain abortion. Okay, we read that part. Okay. Okay. The court concludes the right to obtain abortion cannot be justified as a component of a right. Attempts to justify abortion through appeals to a broader right of autonomy and define one's concept of existence prove too much. It does. It does prove too much, as Nick Reicade has pointed out many, many times. Like, try to apply this logic like anywhere else, and it just doesn't work. Those criteria at high level generality could influence fundamental rights to illicit drug use, prostitution, and the like. Some people are saying, and the problem is? What sharply distinguishes the abortion right from the rights recognized in these cases, on which Roe and Casey relies, is something that both these decisions acknowledge. Abortion is different because it destroys what Roe termed potential life, and what the law challenged in this case calls an unborn human being. None of the other decisions cited by Roe and Casey involve this critical moral question posed by abortion. Accordingly, those cases do not support the right to an abortion, and this court's conclusion the Constitution does not confer a right does not undermine them in any way. So this is trying to preserve, like, for example, Griswold.
Okay, yeah. I understand, yeah. Griswold's the case for the
contraception. Yeah, this Griswold versus Connecticut, because at the time, Connecticut forbid contraception even to married couples. That's Griswold versus Connecticut. That's 1964?
I believe so.
That's
the 60s. But the interesting thing is you see how the court is trying to weave their way out of it, because Griswold is kind of really connected to Roe too, and this right to privacy issue. So they're trying to kind of carve out all this other stuff that's kind of right to privacy, but not really a right to privacy.
Yeah. The concept of stare decisis does not counsel continued acceptance. Stare decisis plays an important role and protects the interests who take action and reliance. It's a little bit harder to find reliance interests here.
Yeah, of course.
And the reduced incentives for challenging settled precedent, saving parties and courts at the expense of endless relitigation. It contributes to actual and perceived integrity of the judicial process, and restrains judicial hubris by respecting the judgment of those who grapple with important questions of the past. But stare decisis is not inexorable. It is its weakest when the courts interprets the Constitution. Some of the court's most important constitutional decisions have been overruled. The court's cases have identified factors that should be considered in determining whether precedent should be overruled. Ironically enough, Justice O'Connor's opinion in Casey itself is a pretty good opinion for this point.
Yeah.
5 factors discussed below strongly weigh in favor of overruling Roe. The nature of the court's error. Like the infamous decision in Plessy. Holy shit.
No, wow. That's a banger. Plessy was like horrible, so they're equating Roe to Plessy. Let's read that one.
Wow, damn.
You got to read that.
Damn, we're not holding anything back. Holy shit.
They just a sledgehammer time.
Like the infamous decision in Plessy versus Ferguson, Roe was also egregiously wrong and on collision course with the Constitution from the day it was decided. Well, geez, we're getting a little spicy this morning, aren't we?
Tell us how you really feel.
Tell us how you really
But you
feel.
know what though? I think they're not writing to only us. They're writing to the dissent. Because you know the dissent is going to be fire like.
Since we're not on Twitter right now, how's the Twitters doing? Are they? Is the Twitters happy? Are the Twitters happy? Are they doing good on the Twitters? Are the Twitters happy? They're joyous. Are there celebrations in the street?
No, they're not celebrations.
How's the Twitters doing? Are they coping well? Continuing on.
But I will say this before we get back. This handed the Democrats a huge win in talking points and all that for the political stuff, because you know now, restore Roe. I can see it now. Restore Roe. This is giving the Democrats a huge thing. I think going into the midterms and the next presidential election, because every presidential election now is going to be about overturning Roe. I bet you.
Or reaffirming Roe, or overturning Dobbs.
Overturning Dobbs.
Well, yeah. I mean, no, we just have to switch sides. I mean, because the pro-life people have been outside the Supreme Court with the tape over their mouths forever,
so long, yeah.
And now the other side can have their turn, I suppose. So there's some sort of something there. Casey preserved the errors, calling both sides of national controversy to resolve the debate, but in doing so, Casey necessarily declared a winner. Thus, those on the losing side, those who could seek to advance the state's interest in fetal right, could no longer seek to persuade their elected representatives to adopt policies. The court short-circuited the democratic process by closing it to a large number of Americans who disagreed with Roe. The quality of the reasoning. Without any grounding in the constitutional text, history, or precedent, Roe imposed on the entire country a detailed set of rules for pregnancy divided into trimesters, much like those that might one to find in a statute or regulation. I mean, there's
Well, that's why Casey. That's why we had Planned Parenthood Casey, because Roe, and this is right. This is right. No matter how you feel about abortion, what he's saying here is right. Roe was more like a legislative issue, the trimester framework, and then Casey had to come in, and then even in Casey, O'Connor said that framework was more legislative. We do judicial principles here, so then we got the standard of undue burden versus this legislative trimester framework. So this is totally correct. In this, the first one I don't really agree with. The second one, I think Roe was definitely badly decided. But again, even Casey pointed this out.
Right. Yeah. I mean, even if you think that somehow abortion is somehow in the Constitution, trying to find the trimester framework inside the Constitution, like
that was legislation. They legislated. That was court legislation, and that's why they overturned it in Casey. So
Roe's failure to even note the overwhelming consensus of state law in 1868 is striking, and what's been said about the common law is simply wrong. Then, after surveying this history, the opinion spent many paragraphs conducting a sort of fact-finding that might be undertaken in a legislative committee, and did not explain what sources it relied on to shed light of the meaning of the Constitution. As to precedent, citing a broad array of cases, the court found support for the Constitution's right to personal privacy, but Roe conflated that right to shield information from disclosure and make right and implement most important decisions without governmental interference. None of the decisions involved was distinctive about abortion. Its effect on what Roe deemed potential life. When the court summarized the basis for the scheme it imposed on the country, it asserted the rules were consistent with, among other things, the relative weights of the respective interests of the day and demands the profound problem of the present day. They are precisely the sort of considerations that legislative bodies often take into account when they draw lines that accommodate competing interests. The scheme Roe produced looked like legislation, and the court provided for the sort of explanation that might be expected from a legislative body. I mean,
from my mouth to the Supreme Court's pages, right? I didn't even read that as of yet. There we go.
I mean, yeah, but I mean, this is not exactly like unexpected in a lot of ways, because the legal scholarship has been talking about this kind of stuff for quite a while. So, like,
you know what? You people should be fascinated by the level of competency that we're giving you right now in this. We're essentially telling you what the Supreme Court is going to say before they even say it.
Yeah, we're just that good. Why are we on the Supreme Court, Dave?
Vote us in.
That's right. And in fact, even more glaringly deficient was Roe's failure to justify the critical distinction it drew between pre- and post-viability abortions.
Yes.
The arbitrary viability line, which Casey termed Roe's central rule, has not found much support among philosophers and ethics who have attempted to justify a right to abortion. The most obvious problem with any such argument is that viability has changed over time and heavily dependent on other factors such as medical advances and the availability of quality medical care that have nothing to do with the characteristics of the fetus itself. I mean, there's something there somewhere.
Yeah.
It's a bit of a weaker argument to me, but whatever. When Casey revisited Roe almost 20 years later, it reaffirmed Roe's central holding, but pointedly refrained from endorsing most of its reasoning. The court abandoned any reliance on the privacy right and instead grounded the right of abortion entirely on the 14th Amendment due process clause. Mm-hmm. The controlling opinion criticized and rejected Roe's trimester scheme and substituted a new and obscure undue burden test. That's been a lot of fun to try to adjudicate.
Undue burden test.
Holy God.
Yeah.
Casey, in short, either refused to reaffirm or rejected important aspects of Roe's analysis, failing to remedy glaring deficiencies in Roe's reasoning, endorsed what terms Roe's central holding while suggesting the majority might not have thought it was correct. That's true. In Casey, also Casey itself was a fractured opinion. There wasn't a majority opinion in Casey.
Yeah, there wasn't. But again, because it's interesting because as an academic, a lot of people don't understand. Casey was trying to fix Roe because so they're not wrong in saying that Roe had a lot of problems. We all knew Roe had a lot of problems, but the fundamental issue about the right to privacy was still there. And then Casey tried to kind of fix that, and we've been living under Casey now this time. And this is just saying, let's stop all the BS, right? This is all bullshit, and we know it's all bullshit.
Apparently, someone in chat just quoted that Thomas said, apparently in some sort of concurrence or whatever, that in the future the court should reconsider Griswold et al.
Ooh.
Which, I mean, logically, Griswold is the one that I think first used the term penumbra.
I think so, yeah, I'm not sure. Interesting. But I don't know. I wouldn't go after Griswold, because going after Griswold, because don't forget, there's still a political element to this, right? If you do go too far, then now you're going to force the courts. Now you're going to force the political branches to want, and you're going to really make the country. You know what I mean? Because the court, even though the court is an apolitical body, but they still have this political piece to it.
Yeah.
Right? And I think if you push them too far, because right now we got the gun right legislation, we got this.
Well, for whatever it's worth, for me personally, I think both decisions are constitutionally correct.
I do. Correct. Yeah, I do. I agree with that.
Yeah. So it's a good day for the Constitution then, because the Constitution has been fulfilled.
I agree. In both instances, I do. I agree.
And apparently, also in the Medicare case, which we didn't really get to, apparently further what would be they say protestations against the Administrative State and against
you and your
against
Chevron.
Chevron.
I love Chevron.
He loves Chevron.
Two-step.
I hate Chevron. No, and Chevron may also not be long for this world. If fate is kind, man. If fate is kind.
Thomas hates Chevron.
Well, me and him both. Depending on whether the precedent should be overruled depends on whether the rule imposes workable, that is, whether it can be understood and applied in a consistent, predictable manner. Casey's undue burn test has scored poorly on the workability. It sure has.
Yeah, it has.
The Casey's plurality tried to put meaning on undue burn by setting out the 3 subsidiary rules, but these rules create their own problems.
Yeah.
And the difficulty of applying Casey's new rules surfaced in that very case. The experience of the courts of appeal provides further evidence. The line between permissible and unpermissible has proven impossible to draw with any precision. Casey's has generated a long line of circuit conflicts. Continuing adherence to Casey's unworkable undue burn test would undermine non-advanced, even-handed, predictable, and consistent development. Effect on other areas of law. Roe and Casey's have led to distortion on many important but unrelated legal doctrines, and that effect provides further support for overruling that decisions. Okay, reliance interests. Overruling Roe and Casey will not upend concrete reliance interests like those that develop in cases involving property and contract. In Casey, the controlling opinion conceded that traditional reliance interests were not implicated because getting abortion is generally unplanned. You can't rely on something that's unplanned. That doesn't really make sense. And reproductive planning could take virtually immediate account of any sudden restoration of state authority to ban abortion. Instead, the opinion perceived a more intangible form of reliance, namely people would organize their intimate relationships and made choices to define themselves and their place in society. I guess I have to be a little bit more careful today on picking up some strange at VidCon or whatever, right?
No, it's just we're California. We're so good.
Oh,
so,
okay.
Yeah.
Well, yeah, I'm just saying, that my options. Well, no, that's right.
Options are great.
California will not only do it; they're going to subsidize it. That's right.
And that's one of the, don't let the people fearmonger you here, right? But, like half the states are still going to have open access to abortions. This is the other half of the states who are saying that that's not for us, and that's what this is. This is giving the states the power to regulate it the way they want and stopping all this fervor. So if you're in a state like New York, California, it's no, but if you're in a state like Texas,
it just became illegal as of just now because they have snapback laws.
Yeah, most of those states have snapback laws. So as of this ruling,
as
it's
of just now, abortion became illegal in what, 21 states?
21,
21 states, 22 states as of this morning because they have snapback laws.
Yeah.
Okay. Okay, the people had perceived a more intangible form of reliance, namely people would organize their intimate relationships, blah, blah, blah. The ability of women to participate equally in the economic and social life of nations has been facilitated by their ability to control reproductive lives. The contending side in this case make impassioned and conflicting arguments about the effect of the abortion right on the lives of the woman as well as the status of the fetus. The case's plurality speculative attempt to weigh the relative importance of the interests of the fetus and mother represent a departure from the original constitutional proposition that courts do not substitute social and economic benefits for a judgment of the legislative bodies.
I like the shade, the court's plurality.
There's some serious shade here. There's some serious Roe-related shade here. The Solicitor General, this is you have to read enough of these opinions to understand this is some serious Supreme Court shade.
This isn't actually shade. This is straight out. You guys are fucking clouds, and we're going to destroy this whole thing. I think we're past the shade. We're in the sunlight. They just called it out. This was bull.
This is what qualifies as a diplomat's diss track.
Yeah. Yeah. This is a rap battle. This is epic rap battles right now. And you should read that. When you read the dissent, it's going to be just as great, right?
Someone asked what a snapback law is. 20-something states have a law that makes abortion illegal immediately if Roe versus Wade is overturned. So that's just called a snapback law because it snaps. It snaps automatically. So 20 states have those laws that make abortion illegal if Roe's ever overturned. It just was, so
those laws are
now in effect. As of like right this second. All right. Casey unidentified another concern, namely danger the public will perceive a decision overruling a controversial watershed decision like Roe as influenced by political considerations or public opinion. But the court cannot allow its decisions to be affected by such extraneous concerns. A precedent of this court is subject to usual principles of stare decisis, under which adherence to precedents is a norm but not inexorable. If the rule was otherwise, erroneous decisions like Plessy would still be the law. The court's job is to interpret the law, apply long-standing decisions of stare decisis, and apply it consistently. Under the court's precedent, rational basis review is an appropriate standard to apply when state abortion regulations undergo constitutional challenge. Given the procuring of abortion is not a fundamental constitutional right, it follows that states may regulate abortion for legitimate reasons, and by legitimate they mean rational basis, which means pretty fucking wide. And when such regulations are challenged, courts cannot substitute their social and economic beliefs for a judgment of the legislative bodies. This applies even when the laws at issue concern matters of great social significance and moral substance. A law regulating abortion, like other health and welfare laws, is entitled to strong presumption of validity. It must be sustained if there's a rational basis. Once the legislature could have thought it would serve a legitimate interest, which is the standard rational basis test. So the legislature doesn't need to identify the interest, and the court needs to go out of its way to figure out any legitimate interest.
Anything, yeah.
Okay, that's standard rational basis, by the way. Mississippi's gestational act is supported by Mississippi's specific findings, which includes the state's asserted to protect the life of the unborn. These legitimate interests provide a rational basis for the act. It follows that the challenge must fail. Abortion presents a profound moral question. The Constitution does not prohibit the states of citizens of each state from regulating or prohibiting abortion. Wrong cases abrogate the authority. The court overrules those decisions and returns the authority to the people. Alito delivers the opinion of the court, in which Thomas, Gorsuch, Kavanaugh, and Barrett join.
5-4.
Interesting that Roberts, well, I don't know if it's that interesting, but at least one thing can be said: you have 5 fucking votes, so I don't have to pull a Marx and start counting.
No, well, hold on. Roberts concurred with the judgment.
Yes, but still, I mean, like, if it was like, you know what I mean? If it was like 4-2 or something.
Yeah.
Like,
this is actually 6-3, to be honest.
So I don't have to pull a Marx and start counting, which makes me very happy.
Yeah.
Roberts, by the way, Marx's decision that tells you how to start counting when you don't have 5 votes. It's a pain in the ass. Roberts follows an opinion concurring. Breyer, Sotomayor, and Kagan follow dissent. Well, that'll give us something to talk about at the water cooler.
Oof.
And it's just the 2 today. Well, that makes sense because they just dropped a bombshell, so we only need 2.
That bomb was crazy.
Wow. We're gonna have to break this down in many different ways, in many different forms. I guess I'll have to change the title of this video to something more explosive.
The overturning of Roe.
The overturning of Roe versus Wade. Yeah, that makes it easy, right? All right, so
How long do you think this decision is going to be? Because if the Democrats or if the libs get, God forbid, they get 5 votes on the Supreme Court.
This is 200.
Done.
This is 213 total pages, by the way.
Yeah.
For whatever it's worth.
Because obviously he has to overturn something like this. You gotta go detailed. That's what Thomas went so detailed with.
Well, let's see how long the opinion of the court is. The opinion of the court is so there's about 4 pages in intro. So the opinion of the court is, or maybe 5 pages in intro. It's a long intro.
Yeah.
Still going.
Yeah,
Still going.
63. You control F dissent.
No.
It's
easy.
No. Get done.
No, it's too easy. It's too easy. I'm committed.
All right.
Shit, it's still going. We're on page 84. It's still going. Okay, so here it is. So it's on page 79. So yeah, that's 79 pages long. Shit,
that
dude.
means a whole other 100 and something pages is the dissent.
Well, there's some appendixes.
There's
some appendices.
Yeah. How long could they go?
They're going for a couple pages.
Because that means it's going to be crazy.
So yeah, as far as I'm concerned, both these decisions on the gun case and the abortion case are constitutionally required because the Second Amendment, actually exists. It's right there. I can even quote it from memory. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. It's right there in the text and everything.
Well, yeah, I think with the...
And abortion, I don't remember that one.
Well, the abortion, I think, is going to be more... It's a political football, right? It depends on your persuasion. If you think, do I believe women should have the ability to get an abortion? Yes, yeah. I believe they should have that right. But is that right the second question, is that right constitutionally protected?
Yeah.
That's the issue. I think you can make a compelling argument that it's not. I think with the gun case, though, I think the gun case is 100%.
Yeah.
I think what New York was doing was just ridiculous. But so with this, I'll say split decision. But we all knew this was coming.
Yeah, and by the way, just because we've made this point a little bit already, but I just want to be 100% clear about what this means going forward. It's up to every state to decide where the line is.
Yeah.
So, as of this morning, that means states can allow all the abortion that they ever wanted to. So all the laws in like New York and California,
None has changed.
None of that's changed. And on the extreme other end, the states can ban all abortion with the possible exception, or with at least my view, the exception of women's health.
Life.
With the woman's life. So if you can prove some sort of imminent deadly threat to the woman, then you got a self-preservation argument. So that's the only, you can't.
But then what about the rape and the incest issues?
I don't think so.
Yeah, because like Alabama, they no matter what, if you get impregnated, that's it. You can't.
I don't think the Constitution requires it for rape or incest. I think it requires it for mother's health, but I don't think it requires it for rape or incest.
See, that's where that's where I think the bridge may be going too far, because I think if someone forcibly impregnates you, that's different than if than even a consensual relationship. Somebody forcibly does something to you, and then you're saying you become now the government can force you to become an incubator. I think that may be.
But it's not the government forcing you. That's the thing, right?
Yeah, because I can't get one, right? The government can't.
But the government isn't the one forcing you to be an incubator, because it's not state action. The one who's forcing you to be the incubator is the rapist.
Yeah. All right. So I'm the incubator. Now I want to get rid of this, right? Let me do, and then they say no. So I don't know. I'm. For those two things, those are my concerns. I think I can see a carve out for something like that. Well, okay, this is going to be protected because you can't force somebody to do this, or can't force somebody in those situations.
Well,
but in other
maybe
things,
it's covered more in the 79 pages.
Maybe it is.
But at least in the 5 or 6 page summary, it seems to be that the line is all the way up to the mother's imminent threat of death or grievous bodily harm.
I don't even think that was in there. I don't think they didn't make that distinction from what you read.
Maybe not. But it's hard.
So all right, reading this, the rule is now, you can ban it for whatever reason. Right?
That seems to be what it says.
That's the rule. So all these distinctions that we're making, I think, is just nonsensical.
It seems to be. I would be slightly surprised if it truly goes that far and says they can ban even for that. Because that's like just basic self-defense theory. But then again, I guess self-defense theory is an aspect of state law. But still, I mean, there's like some fundamental right to self-defense that goes beyond.
Yeah, I know. Well, the Second Amendment gives you a right to the gun, right? Does that imply also a right to self-defense?
I think, well, the Second Amendment itself may not necessarily imply a right to self-defense.
No, but you know what? I suspect if you have a right to life and liberty and the pursuit of happiness, then you would have a right to self-defense, because if somebody's been trying to take your life unjustly, right. So I think the right to self-defense is implied within the Constitution. Yeah. A lot stronger than the right to an abortion, unfortunately. So
yeah, this as always, I take no moral position on whether abortion is good or not. I just take legal positions, and my legal position is that Roe made no sense. Never made sense. It doesn't. You'd be hard pressed to find a lot of people who think it makes sense on its own terms. Even Justice Ginsburg thought it was on the incorrect portions of the 14th Amendment.
Roe was never. No one ever. All right, anybody who's in the know would never say Roe was just perfect, right? Because even Roe, even the court after Roe knew it wasn't perfect. And that's why you have Planned Parenthood v. Casey. But I think at the end of the day, the fundamental principles, Roe's going to be back, right? Roe's when we get enough liberals, it's going to be back.
And that'll be interesting to see if Congress, the federal Congress, tries to pass laws either way, either banning abortion nationwide or requiring abortion nationwide, whether or not they can do that, because I'm not sure there's enumerated power.
Well, Commerce Clause, they probably.
You want to try to squeeze that under Commerce Clause?
They don't do that under Commerce Clause.
Well, they try to squeeze everything else under Commerce Clause, so what else is new, right?
Because the only thing they have to do is show women traveling from one state to another state to get an abortion, and then you got interstate commerce.
Well, to travel between states, yeah, but to require a state to allow abortion on an interstate commerce theory?
No, you just say nobody can ban it, just like you can't ban, just like what they did with civil rights laws, right? One state had things that you couldn't ban black people from staying at hotels, other state didn't. But they were saying because people travel from one state to another state to do this, and you know, and people do
Well,
travel.
I
then
mean,
you
that's a
have
lot
that.
more commercy than, I mean, whether or not a black person can stay at a hotel, Heart of Atlanta Motel, by the way,
Yeah, Heart of Atlanta
whether or not
Motel.
a black person can stay at a hotel or not is much more commercy
Of course, yeah.
than abortion is.
Well, I'm saying a woman saying, "Well, I want to go to this hospital and have this particular procedure." I don't know. I do think this complicated, but I think I can see how they can try to fit it into the Commerce Clause. But again, most people don't realize most of the regulations that we live under are under the Commerce Clause, right? The Commerce Clause
on the federal level.
Yeah, it just gives you everything.
And then that's where we get into rant number 2 for me, where I start talking about Wickard v. Filburn and my thoughts about Wickard v. Filburn.
Oh my God, how powerful is the Commerce Clause? Think about this. And Wickard v. Filburn, the guy was growing wheat on his own farm for him to consume. He wasn't putting it in commerce at all. And they said the Commerce Clause stops him from doing that. So that's powerful stuff. And the same thing for marijuana too.
Well,
Commerce Clause.
I will definitely be reading this decision in more detail as time allows for.
But we got to do 2 things. We got to go eat, and we got to go hit the VidCon.
Go eat, hit the VidCon, all the rest of the things. So don't forget to check out my friend, my buddy, my brother-in-law, Nate the lawyer. I've been Uncivil Law. Like, comment, subscribe, do all the YouTube things. If you're at VidCon, maybe we'll see you along the way. Till then, my friends, hope all's well and peace out.